Well, a major story breaks today about Prince Harry and him dropping his case against Associated Newspapers Limited. And we are here on Black Belt Secrets, so you get my personal views on what really happened. Now, of course, not statements of fact here. I don't have the facts, but I can tell you what I think from my experience. Now, in many cases, when you go to court, you often reconsidering the strengths and the merits of your arguments, and indeed the strategy and the overall stress that it takes on your life. And so many people along that path will change their mind, have a change of heart, and decide not to proceed with their case. But let's back up a bit, just in case you're wondering what case we're talking about and you've forgotten what case we're talking about. This is the case where I know it says Black Belt Barrister at the bottom. We're here on Black Belt Secrets. Please do subscribe. This is the case where Prince Harry accused Associated Newspapers Limited of running a story that made him look dishonest, because the claim here says that the original story claimed that he tried to keep details of his legal battle to reinstate his police security secret from the public. It was published under the headline "Exclusive: How Harry Tried to Keep His Legal Fight with the Government Over Police Bodyguards a Secret." Then, just minutes after the story broke, his PR machine tried to put a positive spin on the dispute. Harry's lawyers said that this story purported to reveal in sensational terms that the information from court documents, quote, contradicted public statements that he'd previously made about his willingness to pay for police protection for himself and his family whilst in the UK. Now, you might also recall that about a month ago, Harry tried to have the defence to this case struck out. The defence being that it was the honest opinion and that reasonable people could hold that belief. And so here is the video that I did on that strikeout application a month ago, which was refused. The judge said that the case will go forward to trial. Here's a reminder of what I said over on Black Belt Barrister about a month ago. The High Court has today refused an application by Prince Harry, the Duke of Sussex, to have the defence struck out, or for summary judgment, in the case against Associated Newspapers Limited. But if you're new to my channel, I'm Daniel Smith, a barrister of England and Wales. Please do hit that subscribe button if you find my content useful. I would really appreciate that. So as I seem to make a habit of saying on this channel, you may be confused as to which case this is and what it's all about. So I would like to provide you a brief summary by referring to the press summary by the Courts and Tribunals Judiciary. So this case against Associated Newspapers Limited by Prince Harry was about this article here, which said, revealed how Harry tried to keep his legal fight over bodyguards secret. Then, minutes after MOS broke the story, his PR machine tried to put out a positive spin on the dispute. This was published in the Mail on Sunday on the 20th of February 2022. And so you'll find that video linked in the description. You can go into watch that for full details. Now, essentially, I think there's a bit around about here in the video about the defence. Let's see what I said here. Defence of honest opinion, set out in Section 3 of the Defamation Act 2013. This is available with certain criteria, which are referenced in the judgment over here at paragraph 37. Firstly, for the defence of honest opinion to apply, the first condition is that it must be a statement of opinion, rather than fact, of course. Secondly, that the statement complained of indicated whether, either in general or specific terms, the basis of that opinion. I've mentioned before, you cannot just say, my opinion of this person is X, without providing the reasoning as to why you form that opinion. So you must give some sort of reasoning. If, for example, you're expressing the opinion that somebody was a fraudster, you must provide a basis of that opinion, which may only be, for example, that they've been prosecuted for fraud. Certainly if they've been convicted of fraud, you can hold that opinion, but that is then the basis of your opinion. The third condition, which is one relevant to this case, is that an honest person could have held that opinion on the basis of any fact that existed at the time that statement complained of was published. And that's the key point here, because the judge essentially ruled that it is entirely possible that an honest person could have held that opinion, or there is a real prospect that this defense of honest opinion could succeed on that basis. And so that leads me to talk about the secrets of what I think is really going on here. Now, to do that, I'm going to compare it with a different type of case, a family case, not a specific case, but family cases, because when we go to court for certain family cases, we have particularly divorce in England and Wales. We have without prejudice hearings at the court, which is really designed for parties to resolve the issues and hopefully come together to draw up a settlement agreement so that it doesn't have to go to a full trial. And in order for that to work, what happens is the parties go before a judge. And so I will go to represent one party, other counsel will go to represent the other party. We'll go to court, we'll put the arguments in their broad form to the court as to what we're going to say, what the parties are likely to argue, what the facts and the underlying core of the dispute is between the parties, what they might be doing to resolve matters, etc. And the judge will give an indication of where they are likely to go on these matters. And so, in essence, the judge is giving a clue as to what the ultimate ruling might be if that judge were adjudicating on the final dispute, the final trial. And in doing so, we come out of court and we have words with our respective client to say, right, now, what the judge has said is that he or she is likely to fall on the side of you or them, and therefore these are the strengths of the arguments in this judge's view. These are the weaknesses in these arguments, in this judge's view. And so taking all of that into account, we might want to formulate our resolution with the other party before going to a full trial. And so if we can do that, that's great because everybody saves time and costs. And so if all of that fails, ultimately it ends up back in court again, but not before the judge that was at the WP hearing. So that sort of gives you a clue. Now, whilst that doesn't happen in these cases, it doesn't happen in all normal civil cases. We don't have these sort of without prejudice, preliminary, what does the judge think type hearing in civil cases. But what some advocates will do at a application to strike out is to seek the judge's views on a particular line of defense, whilst, for example, applying to strike it out. So it doesn't give them the full trial, but it gives them at least a broad shot at the arguments to see how the judge will fare those arguments. And if the judge likes the arguments in the defense, then obviously the judge is not going to strike out the defense. Whereas if the judge thinks that the arguments in the defense will simply hold no water, they are just not going to be strong arguments if the case goes to trial, then in a strikeout application, if there is no realistic prospect of successfully defending the claim, the judge may then strike out the defense. But in doing so, obviously, even if the judge doesn't strike out the defense, the judge might give a hint as to where the case might go, particularly as it might well end up in front of the same judge, particularly in certain cases at a certain level, i.e. it's not with respect to the lower court, it is not just in the county court with a district judge, which could be one of a great many district judges. If it's going to the High Court and there are far fewer High Court judges that are likely to hear the case, then it might ultimately end up before the same judge that heard the strikeout application. And so therefore, the judge might be giving away clues as to what the ultimate decision might be, even though it's obviously not a ruling on it. It's just not a finding of fact. It's not an ultimate ruling on the principles here. It is just a ruling not to strike out the defense, as Harry was trying to do so in December. And within those arguments and within those rulings, within the judgment, there may be clues as to what the judge was thinking at the time. And so we can look to the judgment for some of those clues. So if we move back to that judgment now and take a look, Let me try to enlarge it somewhat so that you can see it. The judge talks about certain facts that the defendant newspaper would need to establish. And at paragraph 62 states that overall it is not fanciful that the defendant will be successful at trial in demonstrating that the public statements issued on Prince Harry's behalf sought to promote the JR claim as his battle against the government's perverse decision to refuse to allow him to pay for his own security. And then says here, there is a real prospect that the defendant newspaper will succeed in demonstrating that this was a misleading description of the issues in the JR claim. And then goes on to describe that I anticipate, says the judge, that at trial, the defendant may well submit that this was a masterclass in the art of spinning. And, the defendant argues, it was successful in misleading and or confusing the public. The resulting media coverage relied upon by the defendant did indeed characterise the JR claim as the claimant's challenge to the government's refusal to offer to pay. And then goes on to say that if the defendant does establish these facts, then I consider that it has a real prospect of succeeding in demonstrating also that an honest person could have held the opinion that the claimant was responsible for attempting to mislead and confuse the public as to the true position, and that this was ironic given that now he held a public role in tackling misinformation. And again, with a subtle hint here, the judge says, as I've noted above, in the context of my decision as to the meaning of the article, my immediate impression was that it was alleging that the claimant was guilty of spinning facts to his advantage. As I suggested in the judgment, spinning can be defined as the presentation of true facts and often an omission of other facts in a way that is designed to give a positive message, but which overall is apt to mislead. And then says, having now seen the sequence of events, in my judgment, the defendant does have a real prospect of demonstrating that an honest person could have held the view that this was precisely what was being done on the claimant's behalf. Now, of course, just to reiterate, this was not a finding of fact in that regard. It was not the judge coming to a decision, a conclusion. It was merely the judge saying, well, yes, there is a real prospect here that the defendant might succeed. And so given the nuances of both the oral hearings and the arguments and any discussions that have gone back and forth in between, and the hearing that followed this one, which would have lined up what was going to happen next, because I understand there was another hearing following this strikeout hearing. Given all of that and just the nuance of, as I say, the nuance of being in court, hearing what the judge said and the tone with which he said it, then further looking at all documents that they might have had, preparing for disclosure. They've taken this right up to the deadline, as I understand that was today. They've taken it right up to the deadline to think, what do we need to disclose? Will these align with this possibility that there's a real prospect that they'll successfully defend and show that an honest person could have held that opinion? And if so, then he would lose. And so the lawyers, I suspect, would have taken any documents that they would have had for disclosure. They'd have taken all of the nuances and the feeling that they get from the judgment and actually being at the hearing, and have had a discussion with Harry to say, all this taken together, it's entirely possible that we're just not going to do enough to get this claim home. And we can save X £100,000, because it would be X £100,000 in all likelihood, if not into seven figures overall in costs, but a substantial amount of money to run this case to trial. And ultimately, if he loses, then obviously it's just a whole chunk of extra money that he would have to pay if he loses. Whereas now, whilst he will be having to pay costs for discontinuing the claim, he will be able to cut his losses earlier than he would had it gone all the way to trial. So that is my take on it. It's the sort of analysis one would do, having been to one of these family without prejudice hearings where we just get a sense of what the judge is thinking and where the judge might go. Now, albeit this a strikeout application, not a without prejudice application and hearing, but as I said, you've got here pages and pages of the judge's thoughts on paper, as well as all the nuances from the hearing. As well, of course, as all of the documents they would have looked at for disclosure that might have undermined their case that they would have to disclose to the newspaper, that they, of course, will then turn around to use against him, if, of course, it does go against him. Equally, he may have just decided, I've had enough. I won the case just not long ago, the phone hacking case, which I've talked about previously. He might have just had enough. He might have just said, look, let's just draw a line under this one. Let's discontinue it. So all of these things are possible. But those are just my thoughts. That's what I think quite possibly happened. They've had serious discussions behind the scenes and just decided not to proceed for any one of those reasons. I hope you found that interesting and useful. Please do hit the subscribe button. We are slowly but surely growing, over 107,000 now here on Black Belt Secrets for my personal views on these cases, an extension of Black Belt Barrister. I deeply thank you for watching. I'm grateful you spend your time here, and to all of you that email me with thanks and thoughts with your stories and how my channels have helped you over the years. Thank you so much. I'll see you next time.